So I know it's been a long day and probably energy is flagging, so I'll try not to be too abstract with my presentation. You'll have guessed from Siobhan's introduction that I come from a slightly different background maybe than many of you here today. With my research is in law and policy rather than in, I guess, clinical or care issues around dementia and Alzheimer's. And my sort of areas of interest would be legal capacity, access to justice and supported decision making. And I work with and I'm interested in people with cognitive disabilities, which is quite a broad church, so it would include, of course, people with dementia and Alzheimer's, but also intellectual disability and mental health. So the issues might vary across the different types of disability and people's different experiences, but I just want to say at the outset that I think planning for the future and thinking about support and exercising capacity is an issue for everyone. It's not just an issue for people with cognitive disabilities. We all might find ourselves in a situation where we're not able to express what we would like to happen, and I think it's something we should really consider very seriously and think about what we would like to do to prepare for that. And I had a really good conversation with Seamus last night about this as well, and he agreed that it was something very important. And I know from talking to him, it's something that he's really thought about and planned himself as well. So that's great. I should say as well that I'm not going to talk too much about the current law because, as Siobhan alluded to, it's not particularly helpful. And I'm sure many of you are familiar with it. The main pieces of relevance today would be, of course, the ward of court system, which we all know is vastly outdated, relies on a definition of unsoundness of mind, and is very paternalistic in terms of its operation, and it's very restrictive. And as a result, there are very few people in ward of court. The only other piece of current legislation that's of use in this context is the Enduring Powers of Attorney Act, or the Powers of Attorney Act rather, and the possibility to create an enduring power of attorney. So I'm not going to dwell too much on those, but if people have questions about their operation, I'm happy to answer them afterwards. So what I'd like to talk about today is to clarify some of the concepts first around capacity, because people use this word capacity in a whole range of contexts, and sometimes, especially to me, it's not very clear what they mean by it. So I want to talk about mental capacity and legal capacity and explain why I think they're different and what the relationship between them has been. I particularly want to talk about our changing thinking on these two concepts, which for me especially has mostly come from the entry into force of the UN Convention on the Rights of Persons with Disabilities and Article 12 of that convention, which recognises the right to legal capacity and the right to support in exercising legal capacity. And then I'll give a quick whistle-stop tour of the process of law reform in Ireland, which is interesting but perhaps disappointing because, as you know, we still don't have new legislation on this. And because we don't have that legislation, I can't tell you what it's going to look like, but I'll talk about some of the things I think it could contain, and I'll talk about what civil society organisations, including Alzheimer's Society and Age Action, have come together to develop some principles about what that legislation should contain. So first of all, the terminology. So when we talk about capacity, are we talking about mental capacity or legal capacity? Mental capacity are the decision-making skills or decision-making ability of an individual, and we all know that that can fluctuate in all of us, depending on the situation, depending on the time of day, depending on the complexity of the decision to be made. Legal capacity, on the other hand, is the recognition of the individual as a holder of rights, so we call that legal agency, or rather legal standing, and as an actor under the law, which is having legal agency. So to be recognised as a person and your actions to be recognised under the law. And the reason for the confusion between the two concepts is that in recent years we have used the fact that somebody might not have a particular standard of mental capacity to remove or deny them a certain type of legal capacity. So if you don't meet a certain criteria of assessment of capacity, subsequently you might have your legal ability to make that decision removed and placed in another person, and that's what we generally refer to as substituted decision making. And usually substitute decision making involves that decision being given to another person who makes the decision in the individual's best interests. Now, it varies from country to country how best interest is defined. In some places it's defined extremely paternalistically and it's more like the interests of society rather than what the person themselves wants. In other places, the wishes and feelings of the person are taken into account, but there is no system that I'm aware of that solely interprets best interest to mean only what the person wants and doesn't take into account other considerations. So there's still other factors other than what the person's own will and preferences is the language of the UN Convention. The other factors other than will and preferences are taken into account in this best interest test. So that's substitute decision making. I'll be talking more about the support model of legal capacity, which says that acknowledging we all have different levels of decision making, ability, but that's not necessarily a reason for removing legal capacity from an individual. So instead of removing it through substitute decision making, you could provide the individual with support and allow them to use, for the person who might be assisting or supporting them to make the decision, to rely on the person's will and preferences, not to rely on some external concept of best interests and what would be best for the person. You'll also hear the term supported decision-making maybe, or assisted decision-making, and I would say that's just one example of the supports that people can get. It's usually taken to refer to a formal support agreement you make with one or more supporters, setting out what areas of decision-making you'd like support with, and how you'd like third parties to respect the people who are helping you to make decisions. So, I think I should have said as well that up until now, I suppose the most recent definition of or assessment of mental capacity is generally referred to as the functional approach, which varies, but generally the main components are whether the person understands the information they're being given about the decision, if they can retain that information, if they can use and weigh it, if they believe it, if they can communicate then that decision to others, and if they understand the nature and consequences of their decision. Which, as I'm listing them off, sounds really hard actually, and if many of us were subject to that for some of the decisions, even major decisions we might have made in our lives, I'm not sure we would all pass. So that's the functional approach, and that's the main sort of assessment of mental capacity that would be in most modern legislative systems. And by contrast then, we get this piece of international human rights law, the UN Convention, which in Article 12 says some pretty radical things. First of all, you'll notice it doesn't talk about mental capacity at all. It only talks about legal capacity. It says that persons with disabilities, including, of course, people with cognitive disabilities, have the right to recognition everywhere as persons before the law, so the right to be recognised as legal actors. It also says that they shall enjoy legal capacity on an equal basis with others in all aspects of life, so all types of decision making. And then it says that states shall take appropriate measures to provide access by persons with disabilities to the support they may require in exercising their legal capacity. So it doesn't talk about any way in which you can remove legal capacity or deny legal capacity. There are two other sections that I haven't put on the slide. One relates to safeguards around supports to exercise legal capacity, and the other is around financial decision making, but I can tell you more about those in questions if people are interested. So what does this mean? First of all, I would say that Article 12 says that there should be no denials of legal capacity. It does not provide in any way for that to happen. Some people might disagree with that and say, well, you know, it says legal capacity on an equal basis with others, so as long as there's a non-discriminatory way to remove someone's legal capacity, then people with disabilities might be subject to that as well. We can have a conversation about that. So I call this the universal legal capacity, believing that legal capacity is something that inheres in every human being, regardless of their level of decision-making skills. So I see as a corollary of that there should not be an assessment of mental capacity which can be used to deny legal capacity. I think you can assess mental capacity for other reasons, primarily to provide support to the individual, but I don't think there should be an assessment that can lead to the denial of legal capacity. I've already talked about will and preferences and best interests, so the language of Article 12 is that any arrangements for supportive legal capacity should respect the autonomy, will and preference of the person. And there's no reference to best interests at all in Article 12, or in the Convention in general, except in Article 7, which is about children with disabilities, and just reflects the language of the Convention on the Rights of the Child. And then a very important part of Article 12 is that supports must be provided for the exercise of legal capacity. So what kinds of things could be a support? For some people, it would just be being given additional time to make a decision, not being put under pressure to make a decision immediately. Other people might want the information about the decision in a particular format that's accessible to them or easy for them to understand. Some people might like the opportunity to consult informally with friends and family or people that they trust, and in fact, I think that's probably how all of us make our decisions. So those are the kind of informal supports that people might use, but supports could also include formal things, like I mentioned earlier, assisted or supported decision-making arrangements, usually a legal document which sets out who are the people who are going to support me, in what areas of my decision-making will they support me, and how I would like others to interact with them. So since we've had the convention, it was finalised in 2006 and entered into force in 2007. And there's a treaty monitoring body for the Convention called the Committee on the Rights of Persons with Disabilities, and they've examined 7 countries to date. And for each of the countries, they have, in respect of Article 12, they have said the same sentence over and over, and it's a version of this sentence, which says, the state must review the laws allowing for adult guardianship and trusteeship and take action to develop laws and policies to replace regimes of substitute decision-making by supported decision-making. And I've highlighted to replace because I think they're using that term deliberately. So it's not just that you can keep substitute decision-making if you develop supported decision-making in parallel or as well, and you can, choose between the two. You must replace substitute decision-making by supported decision-making. Now, they haven't given any further guidance as to how you might do that, so some people have been quite critical of that. But I think we need to start from the premise of replacing and work from there. So what would a support model of legal capacity look like? I'll talk about in a minute how Irish NGOs and civil society came together to develop a set of principles for Irish legal capacity law. But when we did so, we looked at what was available, what was the best practice in terms of this new idea of legal capacity in other jurisdictions. And some of the most progressive work on this has been done in Canada, particularly in the province of British Columbia, where they have representation agreements, which are a form of supported decision-making. And 2 prominent academics in Canada, Michael Bach and Lana Kersner, have written a number of papers outlining what they think a support model looks like. And they say that it should contain 3 components. They've actually revised it since their last paper, I know from my discussions with them, to include a 4th one, which I'll explain. But these are the basic 3 components. The first component is legally independent. So you start off in your interactions with an individual and you assume that they're acting legally independently. They might consult people in order to make a decision. They might require some accessible information, but by and large, they're not using any formal support mechanisms, so they must be legally independent. Supported decision-making then is a formal agreement, as I've said, and this would be probably chosen by people who might have more significant disabilities, more difficulties in communicating their wishes to other people, who might be non-verbal or might use a form of communication that's only understood by very few people. So they might choose to use supported decision-making, have a formal agreement so that if they need to make a financial transaction or something where the individual that they're interacting with is not going to understand what they want, they can use their supported decision-making agreement to help them with that interaction. And then finally, there's this facilitated decision-making, which Michael and Lana describe as a last resort mechanism. And in the work that I and other colleagues have done following on from Michael and Lana's work, we've described facilitated as something that should only happen where you don't know what the person wants and you've tried every method of communication that you can to try to figure out what the person might want, but a decision needs to be made and it's not clear what it is the person would like you to do. And in that case, facilitated decision-making may be required. It would be a person appointed to the individual to work with them, to try and build up their communication, to try to figure out, talk to the people who know the person, try to figure out what it is the person wants, and that they should make that decision that they think best reflects the individual's will and preferences. The 4th component that they've added actually since is called representative decision-making, and that would include things like advance directives or health proxies, where you would make an agreement in advance to say, if certain circumstances arise, I want this person to make a decision if I'm unable to communicate my wishes. So, what are the key components to make this work? Well, as I said, you start from the premise that everyone's legally independent and no one can be forced into a supported or facilitated arrangement. So, again, because we're concerned about some of the ways in which having an assessment of mental capacity might lead to a denial of legal capacity, it would only be offered to an individual. It's not something you can be forced into. As I said, facilitated, which is the most intensive form, would only apply as a last resort where the will and preferences of the individual are unknown, and the role of the facilitator is to imagine or try to discover what the person's will and preferences are and act on that basis. So that's the theory, and then what's actually happened on the ground. So in Ireland, as you probably know, in 2006 the Law Reform Commission produced its report on vulnerable adults, and that was based on a consultation paper that they did in 2003. And the Law Reform Commission report recommended adopting a functional test of mental capacity, and it also recommended having a mental capacity tribunal system to assess mental capacity and appoint adult guardians, and that there would be an Office of Public Guardian to act as guardian for people if there was no other guardian available. And you must remember that this was published at a time that the UN Convention was just being finalised, and I don't think the message about it had spread and people weren't really aware of what its implications were. So certainly the Law Reform Commission's report represented the best information available from other countries at that time. However, after the Law Reform Commission report, when Ireland signed the convention, the context changed somewhat. But even then we still didn't really fully understand what implementing Article 12 would actually mean. So in 2008, the government published a scheme of the Mental Capacity Bill. So it's basically the heads of bill, or the titles of the different sections, and some explanation of what each would contain, but it's not a full bill, if you like. And that bill basically followed what the Law Reform Commission had set out. It only differed in one key respect, which was that this bill said that instead of having a specialised mental capacity tribunal, capacity would be assessed in the courts and it would go through the normal court process. And of course that met with a lot of criticism because people felt that the court system was really inappropriate for this kind of work and that it didn't reflect the recommendations of the Law Reform Commission. After the scheme was published, a regulatory impact assessment was done on the potential legislation, and in that assessment the government stated that one of the reasons for having this bill was that we would need to change our law, we would need to reform the ward of court system before we could ratify the UN Convention. And then after that, not much happened for a while. There were 2 private members' bills, which basically just took the bills that were appendix to the Law Reform Commission and attempted to get them through, but as is the way with private members' bills, they weren't successful. And of course we had an economic crisis, so the idea of what we did about capacity didn't really seem very high on the legislative priority list. So there was a bit of a gap for a couple of years, and the issue got resurrected in February 2011 with the Programme for Government, which said we commit to bringing forward capacity legislation in line with the Convention. And this is the line that we in civil society and the research community have sort of latched onto, because if government is saying we want this legislation to comply with the Convention, our perspective would be, well, if you introduce an assessment of mental capacity that denies people their legal capacity, that will not comply with the Convention. And that's what was the only piece of published work that we have that demonstrates what the bill might look like is that 2008 scheme. And I think everyone acknowledges that it's not really going to look like that anymore, but that's the only piece that we have. So if that's what we have to go on, we might think that it wouldn't really reflect the human rights principles in the UN Convention. So in August 2011, the Oireachtas Justice Committee called for submissions from the public about what the capacity legislation should look like. Everyone panicked because it was August, everyone was on holidays, and we all had to get submissions in September. But people managed to get some things together, and because a lot of us were struggling to put something together to submit to them, Amnesty International's mental health campaign contacted us in the Centre for Disability Law and Policy and said, could we get some people together to talk about their submissions, and maybe if all of our submissions were along the same line, we would have a better chance at influencing the legislation. So we did that, and ever since then we've been convening this legal capacity working group, as we call it. And I think it took us 2 or 3 meetings just to get to the point where we agreed that we wanted the legislation to reflect the UN Convention. We all had different interpretations of what that might mean. So over a process of the next year almost, we decided we would draft a set of principles. We decided if we drafted actual legislation that might not be very helpful, it might not go down very well. So we thought, well, we'll just draft principles for it and take it from there. In March 2012, the Oireachtas Justice Committee held hearings with a number of organisations, many of whom were in this legal capacity working group, about what our views were on what the legislation should contain. And following that, we were able to publish our essential principles, as we call them, for Irish legal capacity law. And we set out 10 principles and key issues under each principle, mostly based, I must say, on Michael and Lana's framework for what a support model of legal capacity would look like. Following that, the Justice Committee published their report in May, and by and large they supported the views of civil society that new legislation should not be based on sort of outdated concepts of substitute decision making, but that it should reflect the will and preferences of the person, and that support to exercise legal capacity should be at the centre of the bill. So that was really positive for us, and ever since then basically we've been waiting to see what the legislation will actually look like. So, as I said, the only piece that's been published is the scheme in 2008. We know we had to act in the Justice Committee hearings as if that was going to be the legislation and critique that. And so we did that, and the Justice Committee took our views on board and said we should move away from the kind of legislative framework that was set out in that scheme of a bill in 2008. Ever since 2012, January 2012, I think, initially it was called the Mental Capacity Bill, and it was listed in the A list for legislation, so with a high priority. And this year it appeared there again in the A list, but it's now called the Assisted Decision-Making Capacity Bill. So that's the only sense we have, or only hint we have, that maybe our thoughts about support model of legal capacity is having some traction, that it moved away from mental capacity to assisted decision-making. But because we still haven't seen the detail of the bill, we really don't know how much it will differ from the 2008 scheme. So these are my hopes, or my questions about what will the bill contain. So I would hope that supports would be central to the bill rather than an afterthought. And I know that there are other concerns that if you build up supported decision-making but you keep open adult guardianship or some other form of substitute decision-making, people will end up in that more restrictive form if there's ever a question. So it would be better, in my view, to keep support as the central part of the legislation and not just an addition or a parallel. I think this, if I had to pick one thing that I would really, above all else, want to see in the bill, it would be that will and preferences would be the core principle, not best interests. And I think that's going to be very difficult to achieve. I think it's very hard for people to wrap their head around will and preferences. What if people have will and preferences to do things that might be dangerous or risky? And generally my answer to that is we might all have that, and there isn't a way in which the law can stop any of us from doing things that might be dangerous or risky, except, of course, there are general provisions of the criminal law and so on that will ensure that there are consequences for people. And of course, we don't like to think that people who make bad decisions might end up in the criminal justice system. But I think that if you have a good support structure in place, that's something that hopefully you can minimise, if not avoid altogether. Another question I would have is, will the bill still contain something that looks like or is called adult guardianship, or will the bill try to adopt this facilitated decision-making mechanism that we've recommended? Another question is whether, if there is some form of adult guardianship, will there be an Office of Public Guardian, or instead would there be an Office of Legal Capacity and Support? Because it really depends on what the purpose of that office is. If the purpose of that office is to provide guidance to supported decision makers, then I think that could be really positive and useful. But if it's put under a guardianship framework, and I know many, for example, Australian states which have an Office of Public Advocate or an Office of Public Guardian that does both support and substitute, and they find that really, really difficult. So I think we should probably avoid that if we can. And my final question, and I think probably I might know the answer to this, will the bill apply to all areas of life? And certainly the scheme of the 2008 bill did not apply to all areas of life. So I think it would be a big challenge to make the bill apply to all areas of decision making. Another question, I guess, is related to this is, will the bill contain something like advanced directives? We are quite hopeful that it will. There were some parliamentary questions asked about this, and Minister Riley committed that his department, which had been separately preparing advanced directive legislation, would coordinate with the capacity legislation drafters in order to include it in the bill. So I think it will include advanced directives, but I'm worried that advanced directives might not survive the Mental Health Act. So if you make an advanced decision saying, if this happens, please don't give me this form of treatment, I'm worried that that might be overturned if you're involuntarily detained and treated under the Mental Health Act. And in many jurisdictions, that is currently the case. So the other areas of life that this could potentially apply to, but I worry about whether they might be excluded from the bill, would be things like voting, jury service, and the Law Reform Commission has recently published a report on jury service looking at capacity to serve on a jury as one of the issues. Of course, the right to marriage and capacity to marry, will that be covered by this bill? And separately as well, the Law Reform Commission has produced a consultation paper on capacity and consent to sex. And again, this is a huge issue, I think probably more so in the context of intellectual disability, but there is quite a regressive piece of legislation in force currently in the Criminal Act of Sexual Offences 1993, which essentially criminalises sexual activity between people with intellectual disabilities unless they are married or unless they are capable of living independently and protecting themselves against exploitation. So that's quite a high test to pass. And again, it's led to service providers to people with intellectual disabilities being very concerned about whether or not they, what level of sex education they can give people, whether or not they can support people to express their sexual identity and issues related to that. So it's a tricky subject. So again, I would be worried that the bill might try to avoid it, but I think it would be very important to try to include these issues if we could, or at least make a firm commitment to address these issues in subsequent legislation. So I wanted to finish with this quote from Bruce Jennings, which is in a wonderful book called Cognitive Disability and Its Challenge to Moral Philosophy, and he's writing specifically about agency and moral relationship in dementia. And he says that I contend that it is the communicative and semantic aspects of human capabilities, not the stress and high-level cognitive skills, that represents what is most worthwhile and defensible in agency or human flourishing theories, or at least in the version of such a theory that we should develop today. Making sense together, remembering a distant past and self, making judgments and expressing evaluations, even though non-verbally through emotional responses and bodily kinetic gestures. These are some of the constituent elements of capabilities of a quality life. So I'll just close on that with a quick plug as well for another conference if you're not conferenced out already. Amnesty and ourselves are organising a conference on Monday in the Radisson here in Dublin on supported decision-making in theory and practice, Ireland's capacity bill. And there are still some places available if you want to attend. Thanks.